Hello, I am attorney Rachel Kuhn here at NP Weiss Law, where we serve Northeast Ohio. Welcome to our channel, where our attorneys answer common questions and share valuable insights into real estate, family law, and estate planning. Today, we're talking about the fun topic of enforcement assessments in condominium and homeowners associations. As an attorney who practices condominium and homeowner association law, one of the things that I am asked about most frequently is, what do we do about that pesky owner who just refuses to follow the rules or refuses to follow the declaration? Can we fine them? The short answer to that question is yes. Condominium and homeowners associations in Ohio do have the authority to impose fines, or the technical term is enforcement assessments, on owners who are not following the declaration, the bylaws, or the association's rules. This comes from often your governing documents themselves, and also Ohio Revised Code 5311 for our condominium associations, and Ohio Revised Code 5312 for the homeowners associations. There are some very specific requirements that the state law sets forward that you must follow in order to do this. And I'm going to work with a fun example here. The holidays are coming up. So let's say you have an owner in your homeowners association named Clark Griswold. Most homeowners associations have a provision in their declaration that prohibits parking of boats, campers, trailers, recreational vehicles, and those sorts of things in a driveway. So let's say you've got an owner in your homeowners association, Mr. Clark W. Griswold, and he has had an RV parked in his driveway for the entire month of December, and it is driving everybody in your association nuts. What can you do about this? You're getting written complaints, it's blocking people's view, it's creating a nuisance. Whether you're a condominium or a homeowners association, the enforcement provision is similar in both statutes. The board must send a letter to the owner prior to imposing any enforcement assessments on their account. There are some specific things that must be in that letter in order for it to be valid. Number one, it has to have a description of the property damage or violation. So in this instance, you're going to send that letter to Mr. Clark Griswold. It's going to say, "Dear Mr. Griswold, according to the Declaration of Happy Holidays HOA, you are not allowed to have an RV parked in your driveway." You're going to quote that provision that he's violating. And you are going to tell him, "It has been alleged that for the entire month of December, you've had an RV parked in your driveway." Then the next thing that letter must have in it is the amount of the proposed charge or assessment. The actual amount is typically up to the board to determine, and it must be reasonable. So let's say the board here has decided that for every week Mr. Griswold has that RV in his driveway, they're going to impose an assessment of $100. Okay, so that's the next thing that's going to go in our letter, is that for every week, we're going to impose an assessment of $100. That letter also has to have a statement that the owner has a right to request a hearing before the board to contest the proposed assessment and discuss this matter with the board. And it also has to set forth the procedure to request a hearing. The owner has to request that hearing in writing within 10 days from the date of the notice. It also has to have a reasonable date by which the unit owner must cure the violation to avoid the proposed charge or assessment. So you could, in your letter, advise Mr. Griswold that he has 7 days to remove the RV from the driveway. If the owner does not request a hearing within 10 days of receipt of that notice, then their right to a hearing is waived. So if you never hear from Mr. Griswold after you send that notice, the RV is not removed from the driveway, the board may immediately at that point impose the enforcement assessment on his account. If, however, Mr. Griswold requests a meeting with the board within that 10-day period, the board must schedule that hearing with him. This is really just inviting Mr. Griswold to the board's next in-person or Zoom regular meeting, giving him 10 minutes to speak his side of the story. Then you tell him, "Thank you, we will make a decision and get back to you." At that point, the board makes a decision whether they're going to impose the enforcement assessment or come up with some other sort of solution. and then they notify him of the decision in writing. If that decision is to impose the assessment, at that point, the board can do this. If these procedures are not followed and you do not give the owner that right to a hearing, it does give the owner grounds at that point to challenge any enforcement assessments that are imposed on their account. As I mentioned before, it's generally up to the board to determine what the amount of that assessment is going to be. Overall, it must be reasonable. It's a good time to pick up the phone and talk to legal counsel, and we can talk about what that reasonable number might be. It is also a good idea for every homeowners association and condominium association to adopt an enforcement policy and procedure that sets forth these procedures, the notice requirement, the amounts of assessments, those sort of things. So everybody is on notice. And also, it prevents the board from selectively enforcing its covenants against the owners. It's a good idea to seek the advice of legal counsel as to the next step because it varies. In some cases, the board may be able to enter onto the owner's property and take the next step and address the violation. If somebody's not mowing their grass, the board might be able to just hire the landscaper and do that and charge them for it. Often a letter from an attorney can help achieve compliance. And if that still doesn't work, a lawsuit can be filed against the owner. I'd also like to point out that tenants, if units are available for rent, if the tenants are not complying with the declaration, the bylaws, or rules, the owner of the unit at that point is also responsible. So you would follow these same procedures against an owner who is leasing their unit if their tenants are not complying. And when it comes to rental units, ultimately, the board can step in the shoes of that owner and evict tenants who are not complying with the declaration and bylaws. Thank you for watching. If your board needs assistance in putting together an enforcement policy that complies with your declaration, bylaws, and Ohio law, or is in need of guidance in taking enforcement action against an owner, please contact my office. I'm happy to help.